So I want to talk about the partial summary judgment motion that I had just filed. The partial summary judgment is just about the grand jury issue and nothing else. And what is the grand jury issue? I'll read there's actually three provisions between America's Constitution and Colorado's Constitution, which I'll read here in a second. But what the grand jury says is that you cannot have a felony charge put upon you unless you are first indicted by the grand jury. That comes from Colorado's Constitution. That comes from America's Constitution. It's the Fifth Amendment. The first sentence of the Fifth Amendment says that you cannot have a felony put upon you unless it's by grand jury indictment or presentment. But it's got to be a grand jury presentment or an indictment. And so the reason why I think I got a very good case, it's a bunch of reasons, okay? So we have an originalist court, right? So the court right now, it's conservative, right? 6-9 conservative, right? So 3 so-called liberal justices, which are really just the Democrats. So they're all kind of conservative in some respects, but 6 of the 9 is just, flat out conservative, picked by a conservative. They are conservative in their mind, body, and spirit, but they're also strictly constructionist. They're originalist. Scalia was a strict constructionist. He was an originalist. And what that means is that the original words of the Constitution is what they mean. You can't change those words and try to mold it for today's society. If you want new words, then you got to get a brand new amendment or a brand new Constitution. When it came to Heller, he says that the decision, he did not want to make the Second Amendment extinct. It was not in his purview of power to make the Second Amendment extinct. We shouldn't make the Fifth Amendment or the Sixth or the Seventh or the Eighth Amendment extinct. All 27 amendments should be good law. So the reason why my case is a good case, there was felony charges, but not only was there not a grand jury indictment or presentment, but there also wasn't a preliminary hearing. There wasn't an evidentiary hearing. There wasn't a preliminary hearing. There was no probable cause hearing whatsoever. At no point in time was there a judicial probable cause hearing. And so maybe, you could look at the situation and say that there was probable cause or that there wasn't probable cause. Maybe there was, something filed. Maybe there was a warrantless affidavit that was filed. So the person, who filed that warrantless affidavit, it no longer works there. So maybe you could say, well, there's probable cause right there. Well, a police officer can't just arrest somebody based upon their own probable cause. The court has to back that probable cause standard up. And when you think about just the spectrum of what's conceivable, what's possible, and then what's probable. Possible is like, maybe something happened. Conceivable is like, okay, I could conceive of something that, terrible would happen. Probable means they probably did it. That means it errs towards, them being, the damn thing being done. If you're like, well, I probably went to the store and bought some Cocoa Puffs, right? Maybe I'm telling the truth. Maybe I'm not telling the truth. Is it conceivable that a person could go to the grocery store and get themselves some Cocoa Puffs? Of course. Is there a possibility? Now, I just made that up, but let's say I had the box, right? Say I had a box of Cocoa Puffs right here, these Cocoa Puffs right here. Now, that's a possibility. He went to the store and got those, he got Cocoa Puffs from someplace, probably at a store, but did he do it, and did he go to that store? And then there's probable cause. Oh, I saw him there. I was there with him. Yeah, he drove, he went into the store, he came back out, he had the Cocoa Puffs. So now, did I get the Cocoa Puffs or not? Well, it's probable. There's a probability versus just a possibility or conceivability. And then you got more standards above probable cause. You have most likely. He most likely got it. And then most definitely. 100%. There's no doubt whatsoever. He went to the fucking store. He got the goddamn Cocoa Puffs. There's no doubt whatsoever. No doubt whatsoever. So probable cause just means you had, a probability, a strong probability that the person had committed the crime. It's necessary. We absolutely have to have it. I want to say that's language that comes straight out of the Fourth Amendment. The Fourth Amendment says you can't have, you can't have seizures without probable cause. Yeah, probable cause comes straight out of the Fourth Amendment. So when you have, Thomas, Barrett, Gorsuch, and Alito, that's, 4 originalists. Not only do you have 6 conservatives, but 4 of them are originalists. Not only did they just incorporate the Second Amendment to the United States, but they also had incorporated the Eighth Amendment excessive fines clause to the states. So the incorporation process is a little bit complicated, but not too complicated. I don't want to get into that just now. So we got 2 things to talk about, right? The incorporation process and then the 3 grand jury provisions. Okay, so what I want to do right now is just kind of lay out the main case for having a grand jury indictment. Not only is it the Constitution of Colorado, it's also the Constitution of the United States. We have an originalist court. 6 of the 9 are conservative. Thomas, Barrett, Gorsuch, and Alito, they are originalists. They are strict constructionists. They are originalists, which means they believe that the words that was written in the Constitution is what it says and says what it means. You can't just change the words and try to, it's not a living Constitution. It's not a living Constitution that grows and changes with times. The Constitution stays the same, and it stays the same forever and ever and ever. Now, we have a hierarchy of laws. You have, the U.S. Constitution. That's the supreme law of the land. In terms of the hierarchy of laws, you can't get no higher than the U.S. Constitution. Some people might complain about the practicality. Well, what about the practicality? If everybody has to get a grand jury indictment for any felony charges, then we can't just throw felony charges on anybody that we want to. Well, that's not that tough. When it comes to the Colorado grand jury, all they need to do is get 9 of the 12 grand jurors to put a felony charge on somebody. So typically, the way that it has been historically and the way the federal government does it is you have 23, maybe 24 people, and then you got to get 12. You got to get 12 of them to say that there's probable cause that a crime has happened. Once it goes past the grand jury threshold, there's a possibility, right? No, not just a possibility, but a probability that a felony has happened. Then it goes to the petite jury. So the grand jury is both a sword and a shield. It both protects, but it also attacks. So it'll protect from frivolous lawsuits, but if the grand jury thinks that a felony has happened, then it's going to go to trial. The trial where there's going to be, the conviction, the big trial. They call it the petite jury because the grand jury is, 24 people, and then the little jury is 12. But with the grand jury, you only need 12 of the 24, so you only need half of them. And then with the petite jury, it would be unanimous. So all 12 of 12. So in some respects, the petite jury is actually the big jury, and the grand jury is the little jury. So the constitutional fidelity trumps practicality. This is what they said when it came to the Second Amendment. They said, my God, if you legalize the Second Amendment now, we're going to have so many hearings, so many court cases. But what they said, the Supreme Court justices, the Supremes, SCOTUS had said that the constitutional fidelity trumps practicality. Okay, it might be a little bit more cumbersome. You might have to do a couple more things. There might be a couple extra steps. But the constitutional fidelity reigns supreme. And so you might have to have a grand jury before you just throw random ass felonies on people. That's a good thing. That's a good thing. You'll just need a little bit more elbow grease. Now, there's also something about when it comes to substantive law, they say it's amendments 1 through 8, but then sometimes they just making up, unwritten. There's an unwritten constitution where they're just making up stuff, and so they got standards for that. And what they had said when it came to the 8th Amendment excessive fines case, and then when it comes to the Second Amendment case, was that they wanted to see that there is a long history and tradition of the right. Not only was the Second Amendment law or the 8th Amendment law, they don't want just the legal history, but they want the people history, the human history, the American history, and the tradition. There's a right to marriage. So a right to marriage comes from the tradition. It doesn't come from the Constitution. It's just made up out of whole cloth. But because marriage is seen as an important institution for stability, for procreation, for civilization, for a bunch of reasons, we Americans have a right to marry. We have a right to marry. And the reason why is because, amongst other things, inter alia, amongst other things, we have a right to marry because it's part of our tradition and it's part of our history. If you take a look at the grand jury, well, the grand jury just goes on and on and on, my friend. If you look at the history of the grand jury, it goes back to before the Magna Carta. There's verbiage in the Magna Carta. It goes to the Assize of Clarendon, the Assize of Clarendon and Hampton something, 1166. Since 1166, we Americans have had the grand jury every century. That's if we're including, the common law back in England. The colonization of Americas was happened in 1600s and 1700s. America becomes a country in 1776. But there's 200 years when we were the British colonists. And then before those 200 years, there was 400 years or so when we had the grand jury. So the 1100s, we had the grand jury. 1200s, the, Anglo-American tradition in history. 1200s, we had the grand jury. 1300s, we had the grand jury. 1400s, 1500s, and then the 1600s. It's still happening in England, but we're doing the colonization of America. We bring the grand jury with us. And so the grand jury has been going strong in America since 1600, 1700, 1800, 1900s, even in the 2000s. Donald Trump, he just got indicted by 4 grand juries in 2023. So 2 years ago, he got indicted by 4 grand juries. So how come he gets the right to a grand jury? Only the rich and the powerful get to have the freedoms that are listed in the Constitution? So the grand jury goes before the Magna Carta. Blackstone's commentaries. Blackstone has mentioned the grand jury. He's actually got a great definition. Blackstone is a common law authority. And then you have, was it Nathan Hale or Koch? One of them talks about it too. I just got the book somewhere, and he's talking about the institutes of the English. He's going on and on about the Magna Carta, so I'd actually like to look into it because it seems like his interpretation might be more precise. 34 of 37 in 1871. So when we had the Bill of Rights, you only had like 7 states. And I say only, it might have been 4 states, I don't know, but there's 13 colonies, 14 colonies, Vermont's like right there somewhere. So you have 1788 Constitution, and then 1791 Bill of Rights, right? Within 2-3 years, you got a Bill of Rights on top of the Constitution. So when I talk about the Constitution, I'm talking about the preamble, the body, and the amendments. So 1791 is when we get the 5th Amendment. 1791 is when we get the 5th Amendment. Well, how many other states had a grand jury clause in their Constitution? Well, not too many of them. Maybe 4, maybe 7 of the 13 or 14. So that's, at least half and maybe less. There's a common law tradition, and they probably were utilizing grand juries, but they didn't have a provision inside of their state constitutions. But that's going to change. By the 1800, there's going to be like another 3 states. I want to say there's 4 states in 1791. By 1800, you had 6 states. So you had 4 states in 1791 when the 5th Amendment was passed. Then you had 6 states in 1800. And then 1871 is when the 1983 Civil Rights Act is going to be passed. Civil Rights Act allows us Americans to sue the government for any civil rights infractions. Well, the 1983 Civil Rights Act is going to pass in 1871. So how many of the states, when the 14th Amendment was passed, and the Civil Rights Act of 1871, which was the 1983, how many of the states in 1871 had a grand jury provision? Well, 34 of 37. 34 of 37 of American states had a grand jury provision. That's remarkable. 34 of 37. 34 of 37 of Americans had a grand jury provision. And then if you look at America today, we got 50 states today, 14 colonies, 900 military bases. I don't know about the colonies or the military bases, but out of the 50 states today, 48 of the 50 states today have a grand jury provision. That's as of June 2025. So the grand jury has been with us the entire time. It's been in our constitutions. It's being utilized. Not only was there Trump, but there is actually a whole bunch of stuff here. I have like a short little list, and you can click on this short little list. just of the history of the grand jury. So I start out with the English history of the grand jury, because technically England doesn't have the common law today. 1933, they abolished the common law, which is crazy because we're using this old ancient English common law here in America when we severed the political bonds, and they don't even use it in their country. I got more issues with the common law, most particularly the ordeals. The ordeal by fire, the ordeal by cold water, the ordeal by boiling water, the ordeal by blood, the ordeal by the cross. So let's go to the beginning, right? You got the Assize of Clarendon. The Assizes of Clarendon and Northampton was King Henry II. So King Henry II instituted the grand jury back in 1166. And then there was, more laws were changed. 1177, he established the grand jury system where you had local informers. They would group all the people. You would have the villages, right? You'd have all these villages, and then the people that weren't in the villages, they would just group them all and call them hundreders. And so they would get 4 men from every village, and then they would get 12 men from every 100. So you have all these rural people. 100 rural people, they would pick 12 of the rural people in order to be a part of this grand jury. And essentially they were the snitches, they were the informers. They were also the ones that would make sure that the people would show up for trial as well. So how did they pick these grand jurors? Well, it was by the sheriff, and the sheriff's tourn, Tourn, also circuit. The sheriff would go around the countryside and go to village to find grand jurors. But its presenting grand jury became so powerful in the 1100s that King Henry II had ordered an inquest of the sheriffs in 1170 to check the power of the sheriff's tourn. The office of the coroner was created. King Richard I used grand juries. Grand jury provisions were included in the infamous Magna Carta of King John's 1166 to 1216. And I have it, there's a little, footnote here, and I put that it was section 13, 26, and 35. And so it's the verbiage, they're talking about a presentment, there's a writ of inquest and a presentment. They also talk about the 100. Nor will any sheriff or bailiff make his tourn through the 100, save for twice a year. So the sheriff or the bailiff would go around finding the grand jury just twice a year, and only in the place that is due and customary, namely once after Easter and again after Michaelmas. And the view of the Frank pledge is to be taken. Okay, then we're talking about the Frank pledge, and then they're also saying you're going to have the same liberties that you had before since the time of King Henry II. So this is King John, right? The Magna Carta is going to be signed by King John, but he's saying you're still going to have the freedoms that you had under King Henry II. So the Magna Carta has language of the grand jury. Afterwards, you got the 1300s. The Magna Carta was 1215 AD, and then in the 1300s, the 12-man grand juries served both to present the indictments and to rule on the validity of the charges. So essentially, you just had 12 men, and they're on the grand jury. They would do the accusing, and they would do the judging, they would do the convicting, they would do the sentencing, and they would do the punishing. So the grand jury did it all. But that's going to change. That's going to change 1368. During the reign of Edward III, the 12-person grand jury became a 24-person grand jury in 1368. During the reign of Edward III, the 12 freemen were superseded by 24 knights chosen by the county sheriff, who had authority for beginning a prosecution. The knights were called Le Grande Inquest, aka the Grand Inquest. So the 24-member grand jury could accuse, but they no longer had conviction power. Now the petite jury was responsible for rendering the final verdict. So we got the grand jury as it is today, has been in Anglo-American history since 1368. Since 1368, we've had this grand jury. I mean, this is 2025, right? So 1300, 1400s, 1500s, 16, 17, 18, 19, 20. That's nearly 7 800 years of having the grand jury as it is today, as it was then, as it is today, in strict continuity. So I'm going to, let's make sure I checked off. There's a long history, so we'll just go on with that. There's a long history. The grand jury is both part of procedural and substantive liberty. And then I got some stuff about Hurtado, but I'm going to come back here in just a second.